Hello, I'm Dr. Neil Payne. I'm the chairman of the board of directors of the Southern Legal Resource Center, and this is All Things Confederate with Kirk Lyons, who is the chief trial counsel.
Hello, everyone. We're here to start a series of programs that will cover all things Confederate. There's a great deal going on in our nation today that involves the Confederate community, Confederate symbols, and the Southern Legal Resource Center, which has been in the vanguard of the fight for liberty and rights for Confederate Southern Americans, thinks that a weekly news program can do a great deal to disseminate information that you, the citizen, can use in our joint fight for liberty. Today's program is going to be about the recently concluded Lexington Lee Jackson event this past weekend in Lexington, Virginia. Great deal of things going on there that are important to everyone, but mostly to the Confederate community. The city of Lexington this past fall passed an ordinance banning Confederate flags and all private flags from their city light poles. These light poles have flag holders that in years past have been used by various groups to display flags during homecomings, football games, patriotic events. VMI has used these poles. The Washington Lee University has used these poles, and for many years, the Sons of Confederate Veterans have used these poles. As a matter of fact, they've been using them since the early '90s, when the city of Lexington actually tried to block the display of Confederate flags in the Jackson Cemetery, and it forced the SCV to file a lawsuit.
Now, do you know how long they have been doing this memorial for Lee and Jackson there in Lexington?
As far as we can tell, and I looked in the Confederate Veteran magazine that we have here in the office, the Lee Jackson celebration has been going on for well over 100 years. Mm-hmm. Well over 100 years. The SCV has been holding parades within recent memory since the late 80s. Mm-hmm. In 1991, the city tried to block the display of Confederate flags in downtown Lexington during this parade, and that's when the SCV had to file a lawsuit. It was a successful lawsuit. They were represented by the ACLU.
So the city of Lexington's been here before on this issue.
Oh, yes. Oh, yes. And as a matter of fact, rather than fight the lawsuit, the city of Lexington agreed to pay the SCV's attorney's fees and pay nominal damages, and signed a consent decree in front of a federal judge in Roanoke to promise that they would never again try to discriminate against the Sons of Confederate Veterans or other groups wishing to display the Confederate flag.
What actually did they agree to in that consent decree?
Well, we happen to have a copy here. The plaintiff in this case, Sons of Confederate Veterans, Virginia Division, filed its complaint on June 1993, seeking declaratory, injunctive, and monetary relief for the alleged abridgment of freedom of speech of plaintiff organization and its members. The case arose out of a rededication on the 100th anniversary of its 1891 dedication of a statue of Confederate General Thomas J. Stonewall Jackson located on his grave in the local cemetery on land owned by the city of Lexington. Members of the plaintiff organization sought and alleged that they were forbidden by the defendants to display the Confederate flag as they marched in the rededication parade or gathered for the rededication ceremonies in the cemetery. Number one, this is what the SCV was seeking. A permanent injunction shall be entered under which neither the city of Lexington nor any individual, corporation, association, or other person or entity under its supervision or within its control may deny or abridge the right of the plaintiff organizations and its members and of any other person subject to the jurisdiction or authority of the parties enjoined thereby to wear, carry, display, or show at any government-sponsored or government-controlled place or event which is to any extent given over to private expressive activity, the Confederate flag or other banners.
Now, would you call those flagpoles government-controlled places?
I would certainly call them that. And what's worse for them, despite, in addition to the fact that they have signed this consent decree, and it's dated August the 18th, 1993, and signed by Sam Wilson, United States District Judge in Roanoke, the poles, because they've been used for so long for this type of expressive activity, have come under the law what is called a limited public forum.
Right.
which means that once created, they cannot so easily get rid of it. It's like the common land in Blackstone's commentaries that have been used for centuries by the people for their own cows and chickens to graze on, and the nobleman comes along and fences it off and says the king has given it to him. Give it to him to use now. Nay, cannot do that. Once government creates a form in that fashion, the current interpretation of the law is you cannot so easily take it away from the people.
So this would be like them erecting a public bulletin board that civic groups could put announcements on, and then deciding, oh no, we can't do this anymore. Only official announcements.
And as a matter of fact, this is something that has been going on across the Southland for several years. Where cities will set up welcome signs and allow civic organizations to put their logo on the sign, like welcome the Rotary Club, the Kiwanis Club, the Lions Club. And what we have seen in years past is when the Sons of Confederate Veterans, a valid nonprofit 501c3 organization, come to put their sign, a logo on the welcome sign, the city fathers have a conniption fit and pull the whole sign down. Just denying the right to express their logo to everyone, not just the Sons of Confederate Veterans. And we at the SLRC have been saying for many, many years, we must attack this as an attack on the First Amendment. And most court legal scholars, so-called legal scholars, say, well, if you deny the right to everyone, then you can get away with denying it to the person you're after, which in this case is usually the Sons of Confederate Veterans. In this case, it's very clear that the ordinance is directed at the Sons of Confederate Veterans. Even though VMI and even though Washington and Lee cannot now put their flags on the pole, it's very clear that the whole focus of this ordinance is directed at the Sons of Confederate Veterans. And we have been saying for years, we must attack them on that basis as well. Not just the fact that it's a limited public forum, but that because they're trying to get at the Sons of Confederate Veterans and keep them from displaying their pole, even though that everyone else can't use it either, that is still a constitutional violation. And God bless the Sons of Confederate Veterans and the attorneys that filed this current lawsuit. They have taken our research on this and put it in the lawsuit in what's called alternative pleading. So yes, they will be saying that because the city targeted the Sons of Confederate Veterans in this ordinance, that is, in addition to everything else, a constitutional violation. Plus the fact that they violated the consent decree of 1993, plus the city created a limited public forum, which they cannot now disintegrate on their whim.
Especially not based on doing it based on the content of our message, which is displayed in the Confederate flag.
Right. So we thought that we didn't know exactly when the lawsuit would be filed. The Southern Legal Resource Center drafted the memorandum of law upon which the lawsuit was based. We also drafted the initial complaint and sent that to the attorneys in Roanoke. Very fine attorney by the name of Arthur Strickland, who's of Northern birth, but a hardcore believer in the First Amendment and the Bill of Rights, and his associate, Tom Strelka, prepared the complaint based on our research and our initial draft. This is exactly how the Southern Legal Resource Center really should work, where we provide the resources and let the local guys on the ground that are right there in Roanoke carry the weight of the lawsuit. Of course, we'll be helping them in any capacity in which they would like help, but it was our research that got this going, and we also, knowing that most Confederate cases are really political cases. And what does a political case mean? That means that the system, the government, the entity that being sued has a very heavy vested interest in the outcome. And all political cases, all Confederate cases generally tend to be political cases. So we also felt that the Sons of Confederate Veterans couldn't just wait for this lawsuit to work its way through the courts. It had to be proactive and get in the face of the city and show them that the public is behind the Sons of Confederate Veterans, not the city in this matter.